All right, good afternoon, everybody, and welcome to the MSHA Mid-Year Enforcement Update and Legal Developments. This is our fourth webinar in the 2018 MSHA webinar series, and thank you for joining. As usual, I am your host, Nick Scala. I am the chair of the National MSHA Workplace Safety Practice Group here at Carey, and I am a certified mine safety professional. As part of my practice, I represent operators and independent contractors in inspections, investigations, as well as the litigation before the Federal Mine Safety and Health Review Commission and beyond. I also help do agent liability cases and whistleblower complaints against operators, and so just really the full spectrum of dealing with MSHA. So today what we're going to talk about, though, is a look back at enforcement, and I have the 2016 versus 2017 data up there because with MSHA they post the 2017 data here in 2018. So we'll do a brief review just looking how enforcement went in the last couple of years. We'll also talk about some enforcement initiatives that are in effect right now and since the beginning of the year in 2018. Additionally, we're going to look at some of what's going on in the rulemaking arena. There's not a lot happening in terms of rules becoming final at this time. We've already had the workplace exam rule become effective back a month ago, but nonetheless we'll look at what's out there on the horizon. Lastly, we're going to go over several decisions from the Federal Mine Safety and Health Review Commission, and actually one from the Occupational Safety and Health Review Commission, which could affect what's going on out in our mines when we get down to enforcement. So as I said before, if you have any questions, please feel free to type them down in the chat function. I will get to them as we go or at the end of the webinar. So with that, we'll go ahead and just take a look at the data from the last couple years. And this comes from MSHA itself, so this is their enforcement data. And when we're looking at it, we can see that we have it broken down into all mines, so coal and metal, non-metal, and then in the two different sectors, because that's how MSHA breaks down their enforcement. Now, there has been talk by the Assistant Secretary of MSHA that they're looking at or considering merging the two metal, non-metal, and coal safety divisions into one, which would mean that inspectors are going to inspect the mines closest to where they're at and not be divided by the metal, non-metal, and coal. You know, that's not imminent. I don't believe that's anywhere near on the horizon, but it's something that has been discussed, and that over the next couple of years we could see explored a bit more and maybe even tested out in several arenas. There's already been quite a bit of shifting in the last few years at the tail end of the Obama administration and of coal inspectors into the metal, non-metal ranks. And this is probably a further effort to consolidate and reallocate those resources as coal enforcement and activity has picked up some, but most certainly not to the levels it once was, and try and streamline the process through which the agency operates. We know that from the discussion on the national stage that the size and number of departments, as well as just kind of the overall efficiency, is a target of this administration. There's been discussion about wrapping up the Department of Labor and the Department of Education into one entity. So there are different items out there for MSHA. It looks like the possibility on that side would be this merger of metal, non-metal, and coal into one single division. Again, that's not imminent, but it has been discussed openly by the Assistant Secretary. But nonetheless, if we're looking at the enforcement data, we can see for all mines this number of citations and orders issued crept up a bit in 2017 from 2016. And if we keep moving to the right, we can see that coal was responsible for about 6,000 of those citations in the increase. Metal, non-metal still went up from 56,000 to 58,000, so a slight increase, about 2 to 3%, but we see a lot more on the side of coal. We can also see, though, that elevated enforcement action, so we're looking at 104Ds, 107As, items such as that, were much higher in metal, non-metal. much, much higher when we look at what was being issued in the coal industry, as well as the rate of S&S citations and orders is higher in the metal non-metal. Now, both of those remain relatively steady, with a slight increase mirroring that of the total citations and orders issued on the elevated enforcement actions for metal non-metal. But overall, the enforcement scheme on metal non-metal has remained pretty steady. What we see at the bottom of the chart, though, is the fatal injury rate, the non-fatal days loss rate, and the all-injury rate. And we can see here that this is where there was really a noticeable decline in the fatal injury rate for metal non-metal, as well as in the all-injury rate. So, we have the industry getting safer, and that's always the goal, but MSHA enforcement stepped up a bit more. And that is somewhat to be expected, because 2016 was an election year, which we typically see a bit of a downturn. As well as 2017, there was no assistant secretary in place. There was a void in that position for quite some time, and then an acting assistant secretary for a brief period. But really what you had was the MSHA personnel who have been in there, the non-appointees, so the lifers, so to speak, were running the show, and a lot of them were running it in a way similar to what we saw under the tail end of the Obama administration. So it'll be interesting to see what happens when the 2018 data comes out. Based on what I am seeing, there is still being a lot of citations issued. In many circumstances, what I'm seeing during inspections is an increase in the number of non-SNS citations being issued from years past, and possibly a slight decline in SNS. But that's not obviously applicable on a universal scale across all mines, but that is just a slight trend that I'm seeing in terms of overall enforcement. As we can see, pretty much steady numbers in terms of the penalties, slightly less penalties issued in 2017 than 2016, but overall that is pretty steady as well. So we've looked at the past, now we're trying to figure out what's going to happen moving forward and what are some areas of emphasis. Now, areas of emphasis in terms of initiatives as well as enforcement emphasis. MSHA does not have national emphasis programs to the same extent that the Occupational Safety and Health Administration does. But they do have a listed initiative in terms of powered haulage. And this is not only an area where they have a program in place, we're also having a rulemaking push, as well as there has been increased enforcement in this area. So powered haulage is a topic that covers a wide range of equipment and tasks and actions around the mine. It includes not only large and small vehicles, but MSHA is lumping in seatbelt use to that. It's also lumping in conveyor belt safety. So, this is an area that there has been a majority of the fatalities in the metal non-metal industry. The Assistant Secretary has not been shy about targeting this as an area in which he wants to see improvement in terms of that, as well as an area where they want to have possibly new rules going into effect or new implementation on the work site about how they can improve interactions between large and small vehicles, because there was a number of vehicle collisions at the beginning of this year and the end of last year, as well as several fatalities that had to do with just not wearing a seatbelt, which at this point in time, everyone should be doing that as an operator. Even if you are training your personnel to do that, you need to try and enforce that as much as possible and try and check on it as much as possible, because if an individual decides not to wear their seatbelt, that citation is still coming to the operator. If it happens to be a serious injury or happens to be a fatality situation, the same rings true. That negligence or that liability is going to fall back on the operator. I know that there was some questions that were asked about possibly creating a scenario with seatbelts where a minor, an individual, could be cited, which at this point that only can happen under very limited circumstances, and it is namely smoking in areas where it is not permitted. where an individual miner can be issued a citation, but I think that's possibly an area that will be avoided in terms of seatbelt use, but nonetheless, they are looking at a wide range of ways to improve power haulage safety. As I mentioned, there is a rulemaking initiative on this, and at the very beginning of it, MSHA has issued a request for an information, or an RFI, and in that RFI, they're requesting data on technology that can be used to reduce the accidents involving power haulage. So what does that mean? It is seeking information about how they can implement collision and proximity sensors on vehicles, including large haul trucks and large mobile equipment. Required engagement for the use of seatbelts has been put out there, meaning the vehicle may not operate unless a seatbelt is engaged, as well as backup cameras being an option that's being looked at. So what is the feasibility about making these requirements on the mine site? Also, in terms of conveyor belt safety, they're looking at how can we continue and improve guarding. Guarding continues and has been one of the most cited areas for the metal non-metal industry for years, and it continues to be year in and year out. And so how can we continue to improve guarding? How can we ensure that there's an electrical shutoff and a lockout tagout being in place when work is going? So is that going to be a requirement of switches for accessing certain parts? Or how can we further that technology to prevent injuries resulting from either mobile equipment or being caught up in moving machine parts of conveyor belts? So again, continues to be an area of focus. We've heard about that for a long time. As I said, it is not new that powered haulage is the leading, if not one of, if not the leading cause of fatal injuries for the mining industry. So this will continue to be an area we hear about, and I wouldn't be surprised if there is some action. I'm not sure if it will be a new rule or if it will just be further implementing technology, which has been a big sticking point or a big area of emphasis for this Assistant Secretary. Another area where we continue to see action on both the rulemaking front and in the enforcement initiative is health sampling. So for underground operations, this is going to be diesel exhaust, diesel particulate. For coal operations, respirable coal dust, as well as possibly diesel exhaust and particulate. And for all operations, silica. Now, we all are probably familiar with the big rule changes that came out for the Occupational Safety and Health Administration regarding silica exposure, in which the permissible levels of silica were drastically reduced. Those rules are in effect at this point, and have been in effect for some time for portions of the industries, over a year. And the thought was for a long time that MSHA was going to follow suit and just adopt the similar regulation and put that into effect with similar levels. Well, that was moved to long-term items with regard to where it was on the rulemaking agenda, and so everyone thought it kind of was gone away until maybe a new administration picked it up and moved forward with it. Well, much to the surprise of many people, it is getting mentioned again as an area where they might explore rulemaking in terms of silica exposure. And in doing so, a lot of that has been due to political pressure. This is still an area that gets a lot of attention on Capitol Hill in terms of silica exposure. There's also the recent data that's come out with regard to the black lung kind of increase in cases found in Appalachia, and there is the thought out there, or some believe that is more so tied to silica than coal dust. So silica is getting a lot of attention. It's something that we're going to continue to monitor. There's nothing happening right now other than rumblings that it could be an area where we see new rules. In terms of enforcement, really last year there was a significant spike back in 2017 in testing and enforcement by MSHA, and really the enforcement of those test results. They also kind of adopted the two-prong approach of OSHA in terms of engineering controls and source elimination over administrative controls. Now MSHA still has the ability to rely on admin controls more so than the new OSHA rule allows operators to do. But in terms of termination and abatement, MSHA was really harping on companies to create this long-term and short-term exposure elimination plans. In doing so, they were pretty aggressive in that enforcement. It continues, especially in operations where there's high silica content. That is an area that MSHA continues to be pretty adamant in their enforcement. We've seen a lot of the elevated issuances in that case, especially if it's a facility where there's repeated issues. So that is something to keep in mind. If you are aware of a silica issue at your facility or of the potential for one, you might want to be proactive in testing for it to see where your limits are or maybe where your sources of exposure are. Additionally, if MSHA is going to come out and you have the ability to do so, I would recommend that you run simultaneous tests with the cyclone or companion samples, as they're sometimes called. This should give you at least the ability to argue the measurement that MSHA takes if they come out differently. So say they register an overexposure and you register an underexposure. So it is something to keep in mind. The health sampling is going to get additional focus and has been, especially with regard to silica in the metal, non-metal industry. Further looking at rulemaking, there has been, for some time, the executive order that was to reform the regulatory agenda. It's also got a lot of attention as an executive order, the 2-for-1, meaning in order to initiate one new rule, an agency or administration had to get rid of two. Now, as part of this, MSHA had an executive order number 13777. This is the regulations to repeal, replace, or modify. MSHA is accepting comments about what standards out there companies, individuals, organizations, associations, whatever entity you might be, propose can be eliminated without adversely affecting the safety and health of the mine site. So they're looking at maybe is this an outdated regulation that no longer applies, or technology has made it not really worth the time of issuance or the time of paying attention to it, yet MSHA still comes out and puts effort into enforcing that particular standard, and maybe it no longer benefits safety and health because there's a better way to do things. The link in this presentation, which you'll all receive, that is to the website where you can review what comments have come in, which is an interesting thing to review, as well as submit your own comment about what maybe you think can be removed from the regulatory handbook. Now again, it's not guaranteeing that anything submitted will be withdrawn or repealed or modified, but they are taking consideration into what the stakeholders provide. So in terms of enforcement in the field, though, where are we seeing the attention? As I said earlier, guarding continues to be one of the top areas for citations in the metal non-metal field, and in mining as a whole, but especially in metal non-metal. The construction and maintenance of guards, as well as having guards in place, which are two distinct standards. So make sure that on moving machine parts we have guards in place, and as we go through the inspections, make sure that our guards are complete so we don't have holes in them. If we are using an area or we have to access an area in terms or to complete greasing, we want to make sure that we have a situation set up where we don't have to reach into a moving machine part or our guard is incomplete in order to complete that greasing activity. So maybe it is having an extension line put out to the outside of the guard, or having a guard that can be moved and swung out of place but then latched back in. We want to make sure that any situation where there is a moving machine part, we do have it adequately guarded. There is still the MSHA PowerPoints that were released earlier in between 2010, 2012, and 2014, which provide some guidance the different phases of guarding, and there is one specific to conveyor belts. So I recommend that you all look at that and make yourself familiar, because that is a lot of what the inspectors are going to look at, and it's also, if you want to contest a citation, a good way to put those arguments in front of the inspector by using their own guidance, and determining that we have set this guarding up to achieve compliance with this document, and that's where we stand. Another one is electrical. That continues to be a big area. Mechanical damage, or protecting against mechanical damage, that really encompasses many, many different things, especially when we're looking at cords, extension cords, tool cords. So, make sure that we have everything in good condition. Make sure that if something is in bad condition and it's removed from service, that we either trash it immediately, make it unusable. I've even seen people snip off the plugs on the ends, or just put a tag on it, because you can still get a citation for a tool or an extension cord that is out of service, you don't plan on using, you're going to throw it away, you're going to repair it, whatever it may be, but it doesn't have the tag on it yet, so keep that in mind. Also on the electrical side, continuity and resistance testing, that continues to be a citation that I see frequently. So make sure that you are following what's required in that standard and keeping record of it. Remember that you need to make those records available, and it needs to happen at least once a year, and when there's any work done, modification or installation of a piece of equipment. Also on the areas where we see a lot of enforcement, this is going to be ground control, and it kind of rolls into those areas that we're seeing an increased enforcement as opposed to years past. Not that these haven't been heavily regulated areas, but that they're getting a lot more attention. Dump points and stockpiles, road construction and berming, which also can go into the stockpile. Are we putting berms up, and are they of adequate height or size or dimension? We also want to look at what our high walls and ground control look like in surface operations. Ground control has always been an issue, and is always a heavily cited standard or standards in underground operations, but we're seeing a lot more of attention focused on that in the surface operations as well. So you want to make sure that if there's any areas of your high walls that are looking out of compliance, or like there might be a hazard present or an area that could be considered a hazard, if we're not using them, we want to berm them off from the bottom. We also want to make sure that we are berming off the tops of our stockpiles or dumping areas. MSHA has put out a lot of best practices on this, and their main focus, one of the areas that they look at regularly is, or try to preach regularly, is dumping at the bottom and pushing to the top if feasible. And if not, you need to have significant bermage in place, or a bumper block or something to prevent over travel. Also, an interesting kind of side note on the dump points and stockpiles is there is actually a standard that requires the inspection of dump points or stockpiles prior to commencing operations on that. So prior to driving up it or working on that, it needs inspected. This is a separate and distinct requirement from the workplace exam. And the way some people, some operations have gotten in trouble on this is previously, when you only had to complete a workplace exam once per shift, this required it to be done prior to the commencement of operations. So I would imagine with the new workplace exam rule in place, that should be less of a concern, but it's something to remember if you are doing those operations, if you're using stockpiles. There is a separate requirement that those be inspected. Now, there's no documentation requirement with that. There's no other description other than it must be conducted prior to the commencement of operations. But as we know with MSHA, if it is not documented, they don't believe it exists or was done. So keep that in mind, just kind of an interesting standard that doubles up on workplace exams at this point, but is still in effect. Again, one could argue that's one that could be recommended for repeal or modification, given the overlapping requirements of the new workplace exam rule. So speaking of the workplace exam rule, we've talked about this many times together, as well as have most other MSHA personnel who should be coming out and discussing with your site, or other individuals who might be providing information on MSHA compliance. The workplace exam rule for the metal non-metal industry was a big change. We heard about it for a number of years. It finally just went into effect in June, albeit there is somewhat of an enforcement period or enforcement-free period until October. MSHA has said that they will not be enforcing the new regulation until October 1st unless they see very dangerous situations or just complete lack of care. So they're giving everyone somewhat of a grace period to continue to get up to date with compliance, as well as review the MSHA compliance materials. So we want to make sure that we are, if we have not already, implementing these changes. I have the full text of the regulation up in here, but this is one of the better breakdowns of it, and it came from MSHA. But just looking at what changed, you know, the big one is when to conduct a workplace exam. You're no longer only required to do it once per shift, but it has to be once per shift before or as work begins in an area. So that or as means that you can technically do the workplace exam while miners begin working in an area. Again, I think that's a situation that is possibly going to be exploited by MSHA depending on the situation and maybe what occurs, especially if there's an incident where maybe someone gets injured at the beginning of the shift while the competent person is performing that workplace exam. You still have the same requirement to promptly initiate corrective action, but you also now must notify miners if there is a condition found in that area that is not immediately or promptly corrected. And MSHA defines promptly as being before a miner is potentially exposed to it. You have to make the record before the end of each shift, and the record is going to have additional requirements on it. So, you know, these are some of the core changes to it. In terms of kind of some best practices, we want to have clear policies on who conducts the examination, when, how we're going to notify our personnel, and how we're going to take corrective action. We also need to be prepared to put down the date that corrective action is taken. You know, we want to do a lot of, or take a lot of steps to ensure that this is a continuous process. We can't just worry or rely on one person to be conducting all of the exams. We're probably going to have multiple persons or multiple competent persons conducting exams depending on the size of our site and how many different work areas we have. Because when we say you can perform an exam before or as work begins, when I hear that, I don't think that means that I can have somebody in the plant doing the workplace exam as someone else begins working in the pit area unless they're directly next to each other, which I don't think is the case in most operations. I would not be afraid to put timestamps on when exams are completed, when corrective action is taken, just so there's no lack of clarity. Also, when we provide notification. We also want to make sure that our independent contractors are aware of this change because they are going to be held accountable to these changes as well. And as we've talked about many times before, ultimately the production operator has strict liability over that site because the Mine Act is a strict liability statute, which means that you can be cited for the actions or inaction of your contractors. So you want to make sure that those are kind of those are the areas that you're paying attention to. Again, this was our last webinar, so I won't beat into it too much. The record changes. It is going to be a much more detailed record than what we're used to, which only required we put the date, name, and area inspected. Now we're going to have the name of the examiner, the date, locations examined, descriptions of any and all adverse conditions found that are not corrected promptly, and then the date of the corrective action. And again, a slight change, but something that we want to make sure we are aware of is these records not only have to be made available to MSHA inspectors now, but also minor representatives if we have those on site. So if you have questions on the workplace exam, if you're working on implementation, feel free to reach out to me. I'm happy to discuss it with you. But I know we've talked about that on several occasions before. So moving forward, let's talk about some of the decisions that have come out from the Occupational Safety and Health and primarily the Federal Mine Safety and Health Review Commission. So for those of you that aren't aware, the Federal Mine Safety and Health Review Commission, it is the third party that hears the cases that you contest between when you contest an MSHA citation. So they hear litigation between operators and MSHA. They were a third party. They're a third party. They're a different organization. They were, though, created under the Mine Act. The commission has a 5-commission panel, and below that they have administrative law judges. Administrative law judges are the first kind of trial court, we'll call it, to hear a case. You can then appeal up to the commission if you want. You can also appeal past the commission into the Federal Circuit Court and the Court of Appeals, and then all the way up to the Supreme Court if you so want, although I'm not sure how many mining cases, if any, have ever made it that far. But those are kind of your options when you're doing the litigation side and when you go through the formal contest. Obviously, if you're going to be exploring informal contest, that is pre-assessment, meaning there's no penalty assessed at that time, so you do not go before a judge. You're just dealing with the MSHA district personnel. So if you get that proposed assessment, you get that penalty in the mail, and you file that contest to that penalty, that's when you're going before the Federal Mine Safety and Health Review Commission. As I said, it's a 5-commissioner panel by design. We have 4, and we have been awaiting the 5th member for quite some time. They are approved through the Senate committee, but not the full Senate. So the political process has kind of got us a bit in a bind. And on top of that, we're preparing to lose 2 of the sitting commissioners in August. So we will be down to a 2-commissioner panel in August, mid-August, unless we get the 3rd commissioner through the full Senate before then. So, odd numbers are there for a reason, so we don't have stalemates. That has not been the case for some time, resulting in a number of 2-2 stalemates at the commission level, which in those cases, the case does not become binding on the industry because it just affirms the judge's ruling. So when we are working on the decisions, if an ALJ makes a decision in a case, that is what we call persuasive authority for other cases, meaning the other ALJs can look to it for guidance, but they're not required to accept what that judge, how that judge ruled and why they ruled that way. If something goes before the commission, as on the appeal of an ALJ ruling, and the commissioners decide a certain way, all the other judges have to apply that logic or that reasoning when making their decision. So if we have a 4-4 commissioner panel and they split in a 2-2, that ALJ decision becomes final, and that is what you would be appealing up to the federal circuits if you decide to. So we might be seeing some 1-1 ties in the near future, which has actually been happening for some time on the OSHA committee, or it did for a while. So that will be an interesting change. The commission also has what they call de novo review authority, meaning they can change the citations and the penalty any way they see fit. They can increase, although that is somewhat rare, the designations, whether it be negligence, gravity, etc., or the penalty itself, or they can reduce them, or just keep them all the same. So they can really do whatever you want, whatever they want once it gets before them. But to focus more on the decisions and the body itself, we're going to take a step back and look at a case that actually affects the mining industry, but went through the Occupational Safety and Health Review Commission, which is OSHA's version of the Federal Mine Safety and Health Review Commission. So same concept, created by the OSHA Act to hear challenges of citations between employers or operators, and the Occupational Safety and Health Administration. So this is an interesting case in Cranesville aggregates because in this case, a mine operator was cited by OSHA after OSHA received a complaint at a bagging facility. So this was a mine that also had a bag house on site where material was dried and then mixed with other ingredients or either bagged as just a dried sand or mixed with other ingredients for cement and sold as such. So the question was whether or not OSHA had jurisdiction over the bagging operation at the mine site. And the OSHA ALJ said, no, absolutely not. That is an MSHA jurisdiction, and vacated the citation. The OSHRC Review Commission did not, they did a 1-1 split on this case. So it went forward, and OSHA, the Secretary of Labor, appealed it up to the Second Circuit Court of Appeals. And in that decision, the Second Circuit gave deference to the Secretary's interpretation of milling. And in doing so, gave OSHA jurisdiction over the bag house on a mine. So why is this important? It's important because it contradicts what has been established as a milling practice for many years, since the OSHA-MSHA interagency agreement was penned. It says in there under drying or under milling that drying is specifically listed as a milling activity. Well, milling activities are the jurisdiction of MSHA. So this is interesting because this Second Circuit remanded and said you have the OSHA has jurisdiction, decide as such. The OSHRC Commission remanded it to the ALJ just recently to decide as such. But we essentially have a situation where the Secretary of Labor decided that this was an OSHA jurisdiction after OSHA went out and issued about $500,000 in penalties. If it was $5,000 in penalties, I don't think they would have argued quite as vigorously. I think they would have said this is milling because there's drying. But essentially what they got into was this distinction between the final product and the beginning of manufacturing from a milling process. And because the material that went through the dryer and then eventually went into the bag house was also sold in that condition as a final product, they said that the milling had been completed and that the use of the bag house and the drying was not to further reform or mill the material, but instead to make it easier to transport or begin in the manufacturing process. So an interesting distinction. I can tell you that I've made the same argument to get facilities out of MSHA jurisdiction and into OSHA, but typically we see this as being a clear line where OSHA has jurisdiction or does not have jurisdiction when drying is taking place. So an interesting case that somewhat flipped on its head what we have always seen as a bright line, that drying is part of the milling because it's included in that memorandum of understanding between OSHA and MSHA, which outlines jurisdiction. So here the Secretary said, no, I'm interpreting it differently, particularly for this case, and we have a bit of a different situation now moving forward, how that could be applied to jurisdiction challenges on the MSHA side. So I'm sure the situation will at some point present itself where a MSHA comes out and issues a significant amount of fines to an operator in a bag house, similar to that in Cranesville, and the MSHA operator makes the argument that it's under OSHA jurisdiction. So when that situation arises, I will be interested to see the Secretary's position because, as can be a frustrating element is when your opposition takes opposing views based on the individual case. And this seems like one of those situations where the Secretary's opinion of what is milling changed so that they could defend a specific set of citations. Another decision that came through the Federal Mine Safety and Health Review Commission recently was a Sims crane. And Sims crane was an interesting case that got a lot of attention because it had to do with a judge outlining a very strict interpretation of the standard regarding not being below suspended loads. And in this case, a crane operator was working on a mine site to participate in the construction of a facility, and MSHA came out on site. And MSHA told the rigger that he could not stand below a suspended load when all that was on the crane was a spreader bar. And under OSHA, that is considered part of the crane and not a suspended load for the purposes of regulation. And at this point, the crane operator got out and walked beneath suspended load, and the MSHA inspector said, "Don't do that, but I need your training documents." And there was obviously a difference of opinion there between the operator and the inspector, and the crane operator walked back beneath the spreader bar to go back to the crane. So I give you that background because the commission did an interesting, took an interesting way to address this case in that they reversed the judge's interpretation of the standard, but they, at the same time, upheld the citation. And the question before them was whether or not the ALJ correctly found that the spreader bar constitutes a suspended load, and being beneath that is automatically a violation of Regulation 56-1609. And so that is where we start. And, you know, it's a very strict reading of that regulation when the judge put it into this effect, and there was a lot of industry support for having this interpretation reversed. A number of associations and companies filed briefs in support of Sims Crane in this. But the regulation itself is very open-ended. It just says persons shall stay clear of suspended loads. So the judge found that that meant the spreader bar was part of a suspended load and that you could never be below it. The commission rejected this interpretation by finding that you could be below a suspended load, and they did that by reading that regulation, 56-1609, in conjunction with other MSHA regulations that offered you the ability to do so. So 56-14-11 includes a number of different provisions, but it also says in the first one, persons shall not work on top of, under, or work for mobile equipment in a raised position until the equipment has been blocked or mechanically secured to prevent it from rolling or falling accidentally. So the commission looked at some of the less ambiguous regulations, as well as an MSHA program policy letter that was issued after the ALJ's decision in Sims Crane, which said if the area is protected and for the purposes of rigging, you can be beneath the suspended load if you are complying with the requirements in 56-14-11. So has the machine been blocked or mechanically secured to prevent falling objects? The commission also said that the section of 56-1609 prohibits miners from being in a fall zone when they're not engaged in rigging work. So they denied the judge's specific interpretation or very narrow interpretation of the regulation on suspended loads, but they still didn't reverse him entirely. And they upheld the citation because the individuals were not in the crane operator was not in the act of rigging when he walked underneath the suspended load the second time, or not in any job-related function other than essentially refusing to follow a safety and health instruction of the inspector. So it's again, an interesting decision where they somewhat split the baby here. They said this is not a strong and fast definition, not a bright line rule where you can never beneath it. You have to look at the factors. So does that mean we're never going to see another citation for someone being beneath a spreader bar under this standard? Absolutely not. But it's going to have to be very fact dependent. What is being done? What was the work area like? What was the actions of the miners, and what was the purpose of it, as well as what safety precautions have been put in place by the operator of the crane. So an interesting decision that we've been waiting on the commission to rule for quite some time. Another area that we've talked about previously, but a decision came out that we've been waiting some time for, was the Sunbelt Rentals case. And in this, it was interesting because the judge initially vacated the citation, and then MSHA appealed that to the commission. And in this case, Sunbelt and a number of other companies were involved, but Sunbelt was the primary defendant. They were constructing scaffolding inside a preheat tower at a facility, and a piece of material fell off one of the higher decks as they were constructing the tower, or the scaffolding within the tower, and injured an employee. So initially, MSHA said that the operator did not perform an adequate workplace exam, and the operator had performed a workplace exam but had not looked at the areas above the top of the scaffolding. And the judge initially vacated the citation, saying there's no adequacy requirement in the workplace exam standard. And that is what the commission, or the secretary, appealed to the commission. And the commission said there's obviously an inherent, in our opinion, adequacy requirement with doing the workplace exams. So they remanded it back to the judge, and the judge found that Sunbelt violated the workplace exam standard because they did not inspect the areas above the working platform while they were doing or constructing the scaffolding. They also found that they failed to adequately examine the upper levels at least once per shift. And I felt like this was the judge trying to kind of point out that the operator had an entire shift to do this. And this is one distinction that we aren't going to have the luxury of moving forward, because again, we're going to have to complete the workplace exams before or as work commences, work begins in an area. So, this not only is going to give some more teeth to the current workplace exam rule, but you don't have the opportunity to kind of do that inspection at any point in the shift. Again, that any point in the shift argument, typically, even in the past, MSHA hasn't really bought into that if there's an injury, because you didn't do it prior to the injury, although that is not the regulation. It was at least once per shift, but now the regulation is you have to do it beforehand. So there's also an adequacy requirement. So, we obviously can't just be paper whipping these workplace exams forms, which we knew to begin with, but we've heard for so long that you didn't do an adequate workplace exam, or you didn't adequately task train someone is another time that word pops up with MSHA. This decision reaffirms that we have to take care to adequately do a workplace exam. Now, I think the adequacy question, that's kind of a easy regulation term for MSHA, because in their mind, if an injury occurred or an incident took place, it obviously wasn't adequate. So we want to make sure that we have our detailed records showing what we do. We want to make sure that we have task training for those persons that are listed as competent, so that we can ensure that we have taken our necessary steps to adequately perform the workplace exam moving forward. The last case we're going to talk about is having to do with the settlement authority of ALJs, and this case is another one that's been around for quite a while. We can see up at the top it is a 2009 docket, but in the American Coal Company, this case was decided by the commissioners. It was actually the second time that it was before the commission. But this is an interesting case where the Secretary of Labor and who acts, the Solicitor's Office for the Secretary of Labor, that acts as counsel for MSHA, and the ALJ, really one ALJ at the commission, are in disagreement over what the Solicitor's Office needs to provide in order to have a settlement agreement approved by the commission. Now, under the Mine Act, in Section 110, the commission has the duty and ability to approve or deny modifications to penalties. And a lot of times in citation or in contest, that coincides with a modification to the negligence or the gravity of a citation. In this case, there was a global kind of 30% across the board reduction in penalty for an operator, and there wasn't all the same coinciding modifications. And the judge denied the settlement. And they denied it previously, and then the solicitor kept litigating it up to the D.C. Circuit, and then they removed that from litigation and contested it before the commission again on another argument. In this case, it was that they needed to provide more facts or explanations, and eventually the commissioners, after the secretary provided some more substantive explanations for the across-the-board penalty modification, did approve that settlement. But it's an interesting case because the operator was essentially drugged through this since 2009 after agreeing to a settlement with MSHA quite some time ago. And it's an unfortunate circumstance where operators are somewhat being held hostage by this disagreement between the solicitor's office and the ALJ. So it's going to, in my opinion, at some point in time, there's going to have to be a change in maybe how the settlement motions are drafted, how much information is in them. Are they going to become a more involved process? Because at this point, they are largely boilerplate with except for some mitigating information that we, on the operator side, insist is included. So we'll see how this shakes out and how it affects the other cases that have suffered similar fates. But right now, this is really kind of the tip of the iceberg that's been in litigation for a number of years. So this could affect how the settlement process goes. It could also affect some of your settlements if you have cases in contest. So be prepared for that. The vast majority, I think more than 98%, of the cases that a settlement is submitted to an ALJ are approved. So these are very, very, very much so the minority. But nonetheless, they continue to be an area where we've seen some disagreements and we continue to see litigation. A number of cases are going through the commission right now dealing with a similar set of facts to the American Coal Company case. So that's where we're going to wrap up for the day. I appreciate everyone jumping on. Just a reminder, you can keep it updated on cases and developments that we've talked about today on the MSHA Defense Report. As well, please feel free to join me for the next two webinars for the MSHA webinar series this year, responsibilities and regulations with contractors, and discussing unwarrantable failures later on. So if there's any questions, I encourage you to ask them now, or feel free to reach out to me by any other means, and I'd be happy to discuss anything with you and be a resource for you. All right, it doesn't look like there's any questions. I encourage you guys, if there's any topics that you would like to hear us discuss, please put them in the comments, and I will be happy to put them on the agenda for the upcoming year. And if I can be a resource for you, feel free to reach out to me at any point in time. All my contact information is up on the screen. So with that, we are done for the day. I appreciate you joining me, and everyone have a good week. Thank you.